Tsilhqot'in decision, it's a clear message. It's a cause for us to rethink the fundamentals of national governance. It's been called a game changer. It's been called, by one of Drew's colleagues, an earthquake that has shaken the legal, historic, and economic foundations of this country. Tonight, what I want to tell you about is some of my thoughts around what the Tsilhqot'in decision means for local government, for Tofino, for Clayoquot Sound, and that rather than being a game changer, it's a rule changer. There's no doubt that the Tsilhqot'in decision has changed the landscape across the country, and the first thing I'll do, if I can make the click through, is just talk very briefly about what local government really is. And you may have heard the phrase that local government is a creature of the province. We are creatures of the province. Local governments are not a constitutionally recognized order of government in Canada. The country is, obviously, provinces are. But if you have heard this phrase that local governments are creatures of the province, what it means is that local governments exist because through the Constitution Act enables provinces to make laws in relations to municipal institutions. And the precise functions of local governments differ across the country, and there are different shapes and forms of local government, from regional districts to counties, municipalities, boroughs. You've heard different terms across the country, perhaps. There are mayors, there are reeves, there are different styles of local government, and each province is a little bit different. I'll focus tonight, obviously, on British Columbia. But it's important to keep in mind this fact that local government is a creature of the province because there is a distinction between the Crown's constitutional obligation to consult with First Nations and a local government's responsibilities to engage with First Nations that are spelled out a little bit under the BC Local Government Act. In a case that the Squamish Nation brought against BC with respect to Whistler's Official Community Plan, or OCP, the court stated that this statutorily imposed duty of public consultation is not synonymous with the Crown's constitutional duty to consult with First Nations. So local governments are creatures of the province, and the province can delegate responsibilities to local government. They can delegate some of the procedural aspects of consulting with First Nations, but they cannot delegate the ultimate responsibility that the Crown has to consult with First Nations. This means it's a little tricky, I guess, when it gets to down on the ground, because local governments are closest to the ground, and that means people are easily accessed. We understand the local context better than the province or the feds will. And this makes it challenging on the ground, but important to understand that in the end, municipalities, like the District of Tofino, can be involved in these procedural aspects, like information gathering, but they cannot be involved in the substantive aspects of consultation that still lies with the Crown, addressing concerns of First Nations and accommodating First Nations concerns. So this could lead to a very frustrating situation, and we might, I think, not be able to rely on the province in the short term to clearly distinguish between these two kinds of consultation, or consultation and engagement. And I think what you're going to see, especially post-Tsilhqot'in, is local governments are going to use the word engage, the word communicate, but they will not use the word consult. So, what does this mean for resource management and land use here in Clayoquot Sound? First, I think that some people may be tempted to think that the Tsilhqot'in decision applies strictly to the specific lands that were named in the case and that Drew showed us on a map, and that other First Nations should be prepared to go to court to prove Aboriginal title. And in practicality, I wonder if this will really be the case. I think that we should all be prepared to proceed as if rights and title exist on all unceded traditional territories. And what we call Crown land, where it is unceded, which is pretty much what all of Clayoquot Sound is. I know that Joe's going to speak a little bit more about the tribal park, so I won't do that. But what the Supreme Court is really urging in the Tsilhqot'in decision is that, like Drew explained, we need to seek reconciliation and resolutions to disagreements through negotiation and not through the courts, which is why I say we should be prepared to proceed as if rights and title are proven on all unceded lands. I doubt that the District of Tofino as a local government will have much to do with the consultation that needs to take place around resource management activities like the proposed mines here in Clayoquot Sound. But the municipal boundaries of Tofino lie entirely within Tla-o-qui-aht, and unceded Crown lands lie within these boundaries as well. The District of Tofino relies on resources that come from the traditional territories of the Tla-o-qui-aht Nation, such as drinking water from Mears Island. And even though the Crown has the constitutional obligation to consult, it still is local governments who must engage with First Nations on projects and legislation that can affect resource use and land use. So things like water, sewer, OCPs, foreshore regulations, boundary extensions, matters like that. And I think that what local governments like the District of Tofino and First Nations need to do is establish very clear communications, protocol agreements, or MOUs with each other that define these terms of engagement. The constitutional duty to consult might live with the province, but it is very clear that writing letters to First Nations and leaving voicemails for First Nations is no longer going to cut anything. And we are now really in an era where both parties have to come to the table together, and that's going to require a lot more outreach, I think, from the District of Tofino to Tla-o-qui-aht First Nations and the other nations in Clayoquot Sound, but especially Tla-o-qui-aht First Nations. And it really will require both of these groups to be at the table together. The Tsilhqot'in Trail, I think, is a good example of moving in the right direction, and I hope most of you have been out on the Tsilhqot'in Trail, and there's a proposal for an extension of the trail that would cross what we call District Block 120, which is unceded territory. It is what we call Crown land, but unceded Tla-o-qui-aht territory. Rather than proceed with applying to the province for a license of occupation to build the trail, the District of Tofino and Tla-o-qui-aht First Nations have been meeting on a fairly regular basis and discussing the extension of the trail. And the District of Tofino finally has received a letter from Tla-o-qui-aht essentially providing us with the consent to work with them to apply jointly for a license of occupation and to work together in siting the trail and in building the trail. I think that's an example of the kind of cooperation and collaboration that we have to have moving forward. Another question that's come up in the media and to me, questions that have been asked, is whether there are legal implications for local governments in formally recognizing First Nations rights and title in an OCP or in a declaration, as the City of Vancouver recently did. And I think that Powell River provides a good example. Their OCP has a core principle in it that requires Powell River to recognize and respect Tla-o-qui-aht Aboriginal rights and title and existing agreements among governments. And in return, Tla-o-qui-aht recognizes that there are neighbors living on their lands and states that they are willing to share lands and resources with them. On the ground, this has not created complications, and instead it's led to relationship building, new projects and partnerships, and I think this is an example that we can learn from. One of Drew's colleagues, again, Murray Brown from Woodward & Company, has stated that in his view, it is highly unlikely that a First Nation would use this recognition statement in an OCP against a municipality in court. Municipalities cannot act unilaterally to bind the Crown. So, important to know. So, Drew spoke somewhat about some of the past court decisions, including Tsilhqot'in, and the requirements for consultation have been spelled out in the courts through a series of cases, most recently Tsilhqot'in. But in 1997, the Tsilhqot'in decision was the game changer of that day, and first decision of the Supreme Court to interpret Section 35(1) of the Constitution Act, which provides constitutional protection to Aboriginal treaty rights. And Chief Justice Lammer says, ultimately, it is through negotiated settlements with good faith and give and take on all sides that we will achieve what is a basic purpose of Section 35(1) of the Constitution Act, the reconciliation of the pre-existence of Aboriginal societies with the sovereignty of the Crown. Let us face it, we are all here to stay. And I think we must be gracious in working with First Nations to move forward with mutual recognition, reconciliation, sharing resources, sharing infrastructure, building better communities. And what we really need to do is we need to be brave enough to start a conversation that matters for us, and that we can do that here in Clayoquot Sound. Thank you.
Aye.